matter from the list from document serial 48, 49. Other side I have informed, but they are not giving.
What is it for?
Milord, it is for IA is there for stay of the distress warrant. The last occasion, both were asked to file the salary slip. Milord, we have filed. Milord, he is paying the regular maintenance. Milord, and he is a government servant.
Come at 1:50.
Okay.
And get hold of the other side.
Yes, yes.
Yes.
Say WPS, which has already been disposed of on 21 to 2024, my lady. Where my lady directed the respondent to file representation before the concerned authority within 2 weeks from the date of the order.
The order has not been uploaded.
Yes, yes.
Yes, it is under correction. I can just modify the order to the extent that 4 weeks time will be done. Give the slip. वो जरा ले लीजिए.
Noted.
Noted.
This case from Delhi list, item 2, WPC 3887 of 120.
This was fixed for 215, I suppose.
Yes, it was time, but 250.
So,
As my lord.
what is it? You are ready?
My lord, I am ready, my lord, but there is one difficulty, my lord. The case was supposed to be, my lord, led by Mr. Rajiv Rajan. Today, my lord, he is leaving for Bangalore, my lord, due to his personal reason. So, my lord, if it is adjourned, my lord, it will be convenient. Because he has to lead because it was fixed for 10:30. I have read, my lord, but he has been assigned to argue this matter because the stake is high.
For last 4 dates, the matter is being adjourned.
My lord, on the last date, my lord, it was adjourned. Their instance, my
No,
lord.
no.
No, not my
It was not adjourned at their instance. It was adjourned at your instance.
And my lord, if you remember, given ample opportunity when you want to fix this case.
Any day, as well, also.
Any day means I do not know. I know only today. कल तो मैंने नहीं देखा. Have you seen? Tomorrow?
I have not seen.
I have not seen. I know only today and this moment. You choose whatever. Since it was fixed for 2:15, I will not insist. Otherwise, I would not have adjourned this matter. As per the order sheet, it is fixed at 2:15. You tell me, when do you want? When do you want?
My lord,
You just give your date.
March. Next Friday, it will come only on Friday. Well, next Friday is holiday. My lord.
May kindly take
No, no, it will not come only on Friday. You choose your date. You choose your date, it will come on the day you want.
Thursday.
आपको
Let
पता
it
है?
be.
Are you aware?
My lord, let it be on 14th or 15th. My lord, I do not say.
On 15th, then you will say it after Holi. No. And
Holi
then you
is
will.
there after 1 week.
That's right.
No,
No, we know that.
I will not say.
You are in a
My
holy
lord,
mood.
I am assuring.
1 week prior to Holi. We know that.
My lord, prior to Holi, my lord, we will argue the matter. I am.
And you
praying
see,
for
you have not
14th
even
or-
filed your synopsis. Not filed. For that also, you need the learned advocate general to do it. You have not filed your synopsis.
I will do that also.
So who is to be blamed for that?
Definitely, my lord, I am responsible, my lord. I assure
You
my
are
lord,
being,
I
you
will-
say that you are responsible, but you are absolutely irresponsible.
No, my lord, I will correct myself, my lord. If that is so, my lord, I will correct myself. I will do that.
No, that is a very long. You asked whenever
15th.
your advocate general is coming back to Ranchi, you give an earliest possible date. You just go and talk to him and let us know the date. We are absolutely at your disposal. We are absolutely at your disposal. No,
I had discussion, my lord. He will
You don't
be
need
coming
to
back
discuss.
on- he will be coming
You just
back on
tell us.
5th, my lord.
he's coming back on 5th.
5th, my lord.
Okay, so on 5th he is coming back. We can post it on 7th.
Let it be on 6th, my lord.
Okay, on 6th. No problem. Okay.
Obliged, lordship, deeply obliged.
Your counsel will come or he will join online?
He was supposed to come, but due to 215
No,
lordship.
no. On the next day he will come or he will join online?
No, he will come, lordship.
Whatever is convenient, no problem.
At 2:15.
We want to do this matter physically, Lordship.
No, whatever is convenient, we don't have any issues.
Deeply looked at.
Okay. Learned Counsel appearing on behalf of the parties have submitted that this matter was fixed to be taken up at 2:15, but because of the notice issued for reference today, this matter is not being taken up. The Learned Counsel for the respondent has submitted that on account of personal reasons of the Learned Advocate General, he is not available today. The Learned Counsel has further submitted that let this matter be posted on 7th or
Sixth.
on 6th of March 2024 on that day
At 2:15, madam.
at 2:15, and on that day Learned Advocate General will be available.
Yes.
The Learned Counsel also assures this court that a synopsis on behalf of the respondents will also be filed by 4th. You file it by 4th.
I will file it by Monday. Yes.
Yes, by 4th.
By.
Pose this case under the same heading to be taken up as first case at 2:15 on 6th of March 2020.
Oblige.
Obliged.
Mr. Devashish Bharuka has a senior advocate has joined online.
Lordship.
आप लोग बाकी लोग अपना appearance से
From supplementary list for final disclosure item 1, WPS 1084 of 2023.
So for that police manual is concerned, my lord, I've gone through that police manual doesn't contain any provision. My friend just now informed there are two police orders. One is of 1988 and another is of 2000. With certain amendments.
which says what?
My lord, 1988 I have said. He said that he will provide me a copy.
No, we will not adjourn it. No adjournment today. For last 3 dates we are adjourning the matter.
In 1988 का है।
What does it say?
This was the first time that Paul.
Is there any minimum age prescribed
Yes,
for
12 to
12
18.
years, no?
12 to 18.
12 to 18.
Done. Yes. Argue your case, please.
Few dates are important. 11th of November 2013. The father died in harness on 11th of November 2013. So leaving behind this petitioner and one minor son, namely Suraj, for whom this petitioner is praying for appointment of compassionate. Now at the shortest, earliest possible time allot, an application was submitted on 27/12/2014, 27th of December 2014, with all necessary documents for appointment of her minor son as Bala Rakshi. Now, madam, it was submitted before ST Hazaribagh, and ST Hazaribagh, madam, in terms of Annexure 2, which is at page 24, that is dated 7/12/2014, forwarded the entire documents, madam, to IG Inspector General of Police, page 24. May I place, madam?
Yes, you please.
Page 24. सेवा में पुलिस महानिरीक्षक हजारीबाग जिला विषय है हजारीबाग जिला के पुलिस संख्या 700 रणधीर कुमार सिंह के पुत्र
I've got it. You just tell the content.
रणधीर कुमार सिंह actually what this letter, the document having submitted for making compassionate appointment on the post of Bala Rakshi, that was forwarded to IG Melor Police Headquarters. Now, at the time, so far as Mr. 3 is concerned, that is the birth certificate, at the time of death, my lord, or at the time of making the application, he was around 4 to 5 years, my lord. Let it be 5 years. He was approaching 5 years.
Give the exact date of birth.
Yes. 26/11/2009.
So he was less than 4 years.
3 years there. It was submitted on 2014. At the time of making an application, it was 4 plus. 26/11/2009 and date of the year of application is 2014.
Yes. We have seen it. You just
Yes.
complete. What is your legal point involved?
It's a legal point. This is the only ground which they have taken with respect to rejecting my claim. They are referred about one circular of 2015 and clause 10.
Yes.
That clause speaks about the time period for making an application.
That's it.
That within 5 years, one has to make an application for seeking appointment on compassionate ground.
That's it.
Here, my lord, the death had taken place in 2013. In 2014, I submitted my application.
That's all. That is all. That.
Thereafter, what has happened?
No, it doesn't make any difference. Even within 5 years, you did not attain the age of 12 years.
I did not attain.
That's it.
My application was kept pending.
We will see that.
Yes.
लिखिए WPS नंबर
एक
10
बार उस लेटर को
हम देख लिए WPS नंबर 1084 of 2023 heard the learned counsel for the parties. District petition has been filed for the following relief. The learned counsel, the foundational dates which are not in dispute is that the date of birth of the petitioner who is seeking appointment on compassionate ground against the post of Bal Arakshi is dated 26/11/2009. His father expired on 11/12/2013. At that point of time, he was less than 4 years of age. On 27/12/2014, within 5 years from the stipulated time for making an application for compassionate appointment, he filed his application, and the matter was under consideration, and by letter dated 13/12/2015, it was observed that the application for his compassionate appointment can be considered only after he attains the age of 12 years, as 12 years is the minimum age for appointment as Bal Arakshi. The learned counsel submits that in such circumstances, the petitioner is entitled for appointment on compassionate ground under Bal Arakshi. This is your case?
This is my case, and in 2014, when it was forwarded to AIG, my lord, then the said authority, my lord, asked the SP to keep this matter again posted before him once he attains the
The learned
majority,
counsel
once he
has
attains
submitted that.
age of
The
12
learned
years.
counsel submits that as per the respondents themselves, the petitioner would be entitled once he attained the age of 12 years, and therefore appropriate order.
This was their letter, Annexure 4.
That's what I've seen.
And when he attains
I have referred Annexure 4 myself.
And when he attains 12 years, and in 2022, and it was submitted again, then they have taken the plea of 2015 circular. Now here the issue is whether the 2015 circular can be applied with retrospective effect.
That's right. The learned counsel for the petitioner has submitted that the circular which was issued in the year 2015 cannot be made effective in view of the fact that the death has taken place prior to the issuance of the circular. That's it. The learned counsel for the respondents has opposed the prayer of the petitioner and has submitted that at the time of death, the petitioner was neither entitled for appointment on compassionate ground under regular appointment, nor under any provision of the scheme for compassionate appointment. He submits that he was not even eligible to be appointed as Bal Arakshi. After hearing the learned counsel for the parties, and considering the fact that on the date of death, the petitioner was less than death of his father on 11/12/2013, the petitioner was less than 4 years of age,
He was
and
only four-
please don't disturb. And at that point of time, admittedly, the petitioner was not entitled for being appointed as Bal Arakshi. As the minimum age for appointment as Bal Arakshi is also 12 years. This court further finds that no such provision has been placed on record by the petitioner in the form of any policy that the claim for compassionate appointment will be kept pending till the minor child attains the age of 12 years or he attains the age of majority. This court is of the considered view that merely because the respondents had issued letters indicating that his claim for compassionate appointment will be considered once he attains the age of 12 years has of no relevance. In view of the aforesaid facts and circumstances of this case, this court is of the considered view that the petitioner is not entitled for compassionate appointment as per any circular or provision of law, as no such circular or provision of law has been placed on record by the learned counsel for the petitioner or by the respondents. In the recent judgment of the Honorable Supreme Court reported in अभी जो कल भेजे थे ना आपको, कल ही आया है, उसका guidelines को quote कर देता है. This court finds no merits in this petition. Accordingly, it is dismissed.
Orders item 2, Criminal 514 of 2022.
Petitioner. Where is the petitioner?
For admission item 3, Criminal 815 of 2022.
Well, yesterday, I wrote a good matter. I had tried my best to satisfy the Supreme Court, requesting the order passed under Section 390. But since my lord disclosed view that lords will not entertain this petition, so my lord says straightway, my lord, I am withdrawing this petition. Now the second point for lords of kind concern. Yesterday, lords may remember, the learned counsel appearing for the informant had made submission that the trial of the petitioner has been split up from the other accusers. That is actually not correct.
We are not concerned with
Now,
that.
I have seen my conversation, why I am making this submission.
Sir, either you argue the case or you don't argue the case. You can't have it both ways. If you want to withdraw, you withdraw.
I am withdrawing it, but there is one IA petition of the petitioner.
No, we will not. You see, while withdrawal of the petition, there is no question of passing any order on the order passed under Section 82 of CRPC. That is not the matter of challenge before
My
this.
submission is, my lords, kindly bear with me for a moment.
Yes.
Kindly bear with me. What I am submitting for my lord's kind consideration is this. Now we have five.
Now I will not allow you to withdraw. I will pass the order on merit. You forget it.
No, I am withdrawing it, my lords. I am at the first instance.
can't, you see,
at the first
At
instance.
the order, please appreciate, the order under Section 82 cannot be subject matter of consideration in this particular petition.
Will my lords permit me to make submission or not? If not, then I will not make submission.
No, it is not a matter of permission.
Madam,
When the matter is posted today only for the purposes of seeking
I am
withdrawal.
withdrawing it, my lord. I am withdrawing it. But one submission which I am making for lords with kind consideration with regard to my IA petition, my lords. My lords, my IA petition, lordship mechanism, the petitioners have been granted anticipatory bail and regular bail by the learned court, the honorable court. Only petition number 3 Sikandar Saw in my humble submission, 82 has been. So, my lord, liberty may kindly be given to the petitioner if lordship is not entertaining my IE petition here in this petition, then we will challenge that order by filing separate petition. That is only submission, my lord. I am not praying that lordship may pass order on my petition. Only to liberty to challenge the order passed under section 82, which we have challenged in, wherein we have prayed for addition of the period in the petition. In my humble submission, lordship may not allow my IE petition with regard to the prayer, but only liberty I am praying that the order which we have prayed for addition in the petition, that liberty will also file fresh petition for
Criminal
it. That is
Division
only
number
submission.
815 of 2022 with IA number 11600 of 2023. The learned counsel for the petitioner has submitted that he has received instructions to withdraw the present this petition.
To take all the points in the court below.
And he also submits that observation may be made to enable the petitioner to take all points before the learned court below, as may be available to the petitioner as per law.
At the appropriate.
Yes. The learned counsel further submits that one interlocutory application being IA number 1160 of 2023 has been filed in the present case for quashing the order dated 13/9/2022, whereby warrant of arrest and order has been issued against the petitioner number 2 and 3,
Yes.
and process under section 82 of CRPC has also been issued. And the process under section 82 of CRPC is also under challenge through this interlocutory application, right?
IE.
In this interlocutory application. Yes.
Liberty may kindly be
The
given.
learned counsel submits that liberty be reserved with the petitioner to avail his remedy with regard to the interlocutory application, with regard to the prayers made in the interlocutory application. The learned counsel
By filing
further
separate petition.
by filing separate petition.
My lord.
After hearing the counsel for the petitioner and with regard to the prayer for withdrawal of criminal revision number 815 of 2022, the petitioner is permitted to withdraw this revision application. However, withdrawal of this revision application however, in spite of withdrawal of this revision application, it will be open to the petitioners to raise their points at appropriate stage as permissible under law. So far as interlocutory application being IA number 1160 of 2023 is concerned, those are subsequent developments, and the present stage of the case is not on record. This court is not inclined to, since the prayers made in the interlocutory application are distinct from the prayer made in the revision application. This court is not such prayer made through interlocutory application could not have been allowed in the present particular proceedings, since this revision application is being dismissed as withdrawn. IA number 11600 of 2023 is also dismissed. However, dismissal of the interlocutory application also will not be an impediment in way of the petitioners to avail their remedies as may be available under law. No, as may be available under law. We do not know. Maybe 83 has been issued. We do not know. We do not know the present stage. We just do not know anything about it.
They are on bail, appearing on every date before the court below.
Then why 82 has been issued? If you are on bail.
Well, that is, I've got a copy of the order.
That's very
I think
good.
it's victory bail.
You have your remedies as per law. We will
Well,
not
that's true,
pronounce it.
but wrong submission was made कि trial split
कोई
हो
बात
गया, ये हो गया,
अब
वो
withdraw.
गया, not proper.
IA is also dismissed. The main revision is also dismissed as withdrawn.
Split up हो गया lottery बार
We are not concerned. We are not concerned with that.
order I have got
No, we are not concerned.
lottery.
We are not concerned.
Copy दे दीजिएगा तो हमको.
I am there sir.
Chaliye.
Oblige.
Item 4, Provisional 1075 of 2022.
What is it?
May I please your Lordship, in this case, the petitioner has been convicted for 6 months and a compensation award has been awarded in favor of the opposite party to the tune of 1 lakh 50,000. I have filed an ID press for bail because the petitioner has surrendered before the learned court below on 16/2/2023. My lords, my contentions shall be of twofold, basically. Firstly, my lord had disclosed with you that 20% of the amount subtracting the 30,000 from 1 lakh 50,000 shall be deposited for the condition of bail. And secondly, my lords, three points. If on merits for the sake of bail, I am just arguing for the right now. Firstly, my lords, in this case, what had happened, the notice, 138B notice, was served in the name of Mitresh Rajak, son of Lakhan Rajak. Whereas, my father's name was Bajrang Rajak. And PO Ramgarkant and a pin code was issued, but
Son of
Bajrang Rajak.
Mitlesh Rajak, son of? Notice
When
was
notice was issued, it was issued in name of Mitlesh Rajak, son of Lakhan Rajak.
So you dispute your identity?
No, I don't dispute my identity, but the notice was not served in the correct name of the correct person. This shall be my point of argument just for the sake of it. That
Father's name was wrongly mentioned.
Huh?
The father's name
Yes,
was wrong.
absolutely.
गलती से गलती से
And
ठीक है, ठीक है.
वो absolutely.
You just hold.
Yes, ma'am.
Yes. What else? For bail, what else do you want?
Just yesterday, I was just observing the court and just 1-2 points which my laws were observing that legal debt.
Even for bail, I have to cite 2 points, so I'll cite this.
That's for that reason.
But condition of bail is a different thing altogether.
I bow down to that fact, my lord. Another point, my lord.
I will grant you bail.
हाँ, तो legal debt वाला वो point पे ले लीजिए. Legal debt is not too
It was a security check.
See, it was not a security check, my lords. What had happened? I'll just
No, it's okay. Not much is required for bail. That
Yes,
is.
my lords.
That too under 138. What is the check amount?
1 lakh 50.
1 lakh
50.
50,000. How much did you deposit?
30,000. So 1 lakh 20,000.
during appeal.
24,000.
You deposited 30,000.
Yes, my lords. 24,000. Yes.
Already deposited.
Yes, my lords. The counterfoil receipt may be taken on record also, if my lords.
Deposited it before?
Before Nazarat, Lalat Court, Nazarat.
Appellate court.
Yes, ma'am. In criminal appeal 18 of, if my
You
lords.
deposit further 20,000?
Yes, ma'am.
I grant you bail.
Yes, my lords.
Yes.
You want to argue the case finally? If the LCR would have been there, we would have taken up the matter. LCR is not there.
LCR.
That is required.
If LCR would have taken, was on record, my lord, yesterday, not just whatever would be, I was perusing going through the judgment passed by my lords in Mohammed Naseem case. This how post 138B was interpreted by my lords, and what's the importance and relevance of 138B with respect to notice. Although it was a registered post case, but it was a very beautifully written judgment taking this case also.
Total revision number 1075 of 2022. The learned counsel for the parties are present. IA number with IA number रहेगा. IA number 2099 of 24. The learned counsel for the petitioner has submitted that the petitioner is in custody.
Yes, my lords, I have surrendered.
Yes. It's okay.
16 to 2020.
The petitioner is in custody since 16 to 2024, and the interlocutory application has been filed for suspension of sentence and grant of bail. The learned counsel has submitted that at the appellate stage, the check amount is for an amount of rupees 1,50,000. At the appellate stage, the petitioner had deposited rupees 30,000. He submits that he has a prima facie case in as much as the notice was issued in the name of petitioner, but the parentage was wrongly given. He has also submitted that the records would reveal that there was no legally debt payable by the petitioner. You are for OP?
Yes,
The learned counsel for the opposite party number 2 has submitted that both the courts below have rightly passed the orders, which does not call for any interference. However, he submits that the records from the court below, records from the concerned court would be required. he also submits that the petitioner may be directed to deposit some amount as some more amount as a condition for bail. After hearing the counsel for the parties and considering the submissions made by the petitioner regarding the merits of the case, this court is inclined to suspend the sentence of the petitioner and enlarge the petitioner on bail subject to following conditions. One of the bailer, 25,000 two securities. One of the bailer should be close family member. Deposit of rupees 20,000 before the learned trial court.
Learned trial.
Learned trial court. Right? And your Aadhaar should be submitted. Your phone number should be submitted. You will not change it. That should be sufficient.
Let's move.
IA numbers 2099 or 24 is allowed. Let the records of the concerned court be called for. Post this case under the heading for final disposal on 4th April.
Grateful permission.
You prepare your notes.
I'll definitely prepare.
Okay.
From daily case for final disposal, item 1, WBC 1450 of 2014.
This is not Mr. Mahesh Tiwari has to argue, not he is on leg, not on court number 9. So let it be not passed over one or two cases.
It will be taken up at 12:30.
12:30.
Item 4, Revision 524 of 2022.
Petitioner. Records has come. Petitioner absent. क्या heading में है ये? What is the heading of this case? You are there?
Merits.
You are there in this case?
I am in this case, merits.
Are you?
In view of previous order merits, one supplementary we have already filed yesterday merits.
I've seen your argument. You just argue the case on merits.
Merits. By the impugned order merits dated 10/3/2022, the order of maintenance has been accorded to 7,000 with respect to the OP number 2 and others merits. In this case, merits, although the marriage was solemnized in the year 2016,
2016.
merits,
Yes.
that is 12/7/60.
12/7/16 marriage.
But after that, she doesn't want to lead a conjugal life with this petitioner
for which he tried his level best. And even
One son was also born.
One
You
son
said that
was-
after marriage he doesn't want to live with you.
just after that, my lords, during that period, my lords,
Your son?
it is my son, my lords.
There is
is
no doubt on that.
No.
What is the date of birth of the son?
That has not been
Not.
mentioned, my lords.
Anyways, then
And thereafter, my lords, when the matter has not been solved, my lords, we have filed an application under Section 9 of the Hindu Marriage Act, my lords. And
when
that,
did you file it?
It was filed in the year 2019.
It is mentioned in the impugned order?
In the present impugned order, it has not been mentioned.
No, we are not concerned with that.
Although-
Things which you have not placed before the learned court below, in
As-
revision application, we will not take that into
As
consideration.
because, my lords, in the impugned order, it appears from paragraph 3, my lords, that the court has departed from filing any show cause, my lords.
That's right. Rightly so. All right.
And numbers of cases is going on
Between
regarding
the
the
parties.
criminal case and this civil suit, my lords.
Criminal cases, civil suits are pending between the parties.
Pending between the parties. Criminal case with respect to 498A.
498.
Matters. And for which numbers of time mediation was also going on at the charge and itself.
That's it.
So far the contention of this petitioner is
So what is
concerned-
your ground?
My ground is that, my lords, first of all, my lords, I was debarred from filing this over. I could not defend my case properly, my lords. Number two, there is no specific source of income regarding the maintenance, my lords.
Only 7,000 has been awarded.
7,000, we are in fact an unemployed persons, my lords.
You are unemployed.
My lords.
You should have thought before marriage.
That's there.
You
That's
should have thought before marriage.
my lords. But
That once you get married, you
but
have
so-
some responsibilities.
So far reconciliation is concerned, my lord, so we have tried our level best and also filed a petition under section 9 that was decreed in my favor much prior to the filing of the present case, my lords. That is
Ex
an
parte?
acceptable.
Ex parte?
That's what it is.
Then when your right to file the show cause was rejected on 4/12/2021,
4/12.
you never approached the court for recall of that order, nor you approached the High Court to set aside that order.
That's right, my lords. It appears from the include order
Thank you.
that has not been done, my lords.
This criminal revision number 524 of 2022. The revision application has been filed for the following relief. The learned counsel for the petitioner, while challenging the impugned order passed by the learned family court, has submitted that as recorded in order dated as recorded in the impugned order in paragraph 3, the petitioner was debarred from filing the show cause by the order dated 4/12/2021. The learned counsel submits that under such circumstances we could not bring on record the order passed in the case of restitution of conjugal rights dated
Dated second 20
second dated 20/2/2020, and though the same was decreed ex parte. The learned counsel has fairly submitted that neither any petition was filed, that no steps were taken by the petitioner to challenge the order dated 4/12/2021 by which the petitioner was debarred. He neither filed any petition for recall before the learned family court, nor any petition, nor the same was challenged before any higher court. The learned counsel has also submitted that there are numerous cases pending between the parties, including one criminal case filed by the opposite party number 2 under section 498A of Indian Penal Code. He has also submitted that the petitioner does not have any source of livelihood and therefore the impugned order calls for interference. The learned counsel has also submitted that the learned counsel appearing on behalf of the opposite party while opposing the prayer has submitted that the marriage is not in dispute. A child was born out of wedlock is also not in dispute. He has also submitted that the amount of compensation which has been awarded to the opposite party is a meager amount of 5,000 for herself and 2,000 for the child. The learned counsel has also submitted that the fact that there is a criminal case pending against the petitioner for alleged offence under section 498 capital A of Indian Penal Code is also not in dispute. The learned counsel has also submitted that though the petitioner was debarred from filing the show cause, but at the same time the witnesses produced by the opposite party number 2.
Your Worship, may I submit one? He had given sufficient opportunity.
That's right. The witnesses produced by the opposite party number 2 who had testified that the petitioner runs a furniture shop and earns rupees 50,000 to 60,000 per month were duly cross-examined by the petitioner. The learned counsel submits that considering the learned counsel has also submitted that so far as quantum of compensation is concerned, the same was also rightly considered, as the OP number 2 did not bring any documentary evidence with regard to the income of the present petitioner. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that the impugned order reflects that in spite of service of notices, the petitioner did not file his show cause and ultimately he was debarred from filing the show cause by the order dated 4/12/2021. It further reveals that the said order was never challenged by the petitioner before any court of law. The petitioner had participated in the proceedings inasmuch as the witnesses produced by the opposite party, by the wife before the learned court, were also cross-examined by the petitioner. It further appears that the wife had claimed that the petitioner had income of 50,000 to 60,000 rupees per month, but the learned court has taken into consideration that through his furniture shop, but the learned court has taken into consideration that no documentary evidence with regard to the income of the present petitioner was filed by the wife, and the learned court has considered the status and the living standard of the present petitioner, has awarded an amount of rupees 5,000 per month to the wife and rupees 2,000 per month for the purposes of maintenance of the son. Although the maintenance was claimed at the rate of rupees 5,000 per month for herself and rupees 5,000 per month for the minor son. This court finds that the learned court framed the relevant issues, including the issue as to whether the wife had sufficient reasons to live separately. This aspect of the matter has also been considered, and the fact that the wife has also filed a criminal case under section 498 capital A of Indian Penal Code is not being disputed even by the petitioner before this court. Rather, the petitioner himself has submitted that there are multiple cases going on between the parties. This court, after going through the impugned order, does not find any illegality or perversity calling for any interference. Accordingly, this petition is hereby dismissed. Interim order stands vacated. Communicate.
For orders at item 5.
एक चीज और लिख लीजिए. The law is well settled that in case of any changed circumstances, the parties have appropriate remedy under the provisions of section 127 of CRPC.
For orders item 5, Resolution 850 of 2022.
Why is it listed for orders? Why is it listed for orders? आइए. आइए नंबर.
9540 2.2.
7645 9650
9540.
Where is the petitioner? Nobody appears on behalf of the petitioner. From the records of this case, it appears that provisional bail was granted to the petitioner for a period of 4 months, while order dated 17th January 2023, and the matter was directed to be posted on 28th of March 2023. Thereafter, the provisional bail has not been extended by any order passed by this court. Since the period of grant of provisional bail, okay, just a minute. Thereafter, an order dated 28th of March 23 has been passed, and pursuant to such order, the provisional bail was extended till the next date. When the case is called out today, the petitioner is absent. Post this case on next Thursday under the heading for orders, and if the petitioner would remain absent on the same date, the appropriate order for surrender of the petitioner will be passed. This court observes that once the provisional bail that should be enough. Next Thursday, continues.
7. Item 6, Criminal Division 1362 of 2022.
Yes, petitioner.
This not the revision is directed not against an ex parte order is passed under section 125 of the CRPC by the
Notices were not served upon you.
yes.
Where have you stated that the notices were not served?
Not
Show me which paragraph, and from where are you saying the notice was never served upon you?
kindly not have a look to not page number
Yes?
page number not 53 and 54.
53 and 54. Are you joining online? For this matter? You are for whom? Opposite party?
I am from order number 2 and 3.
Okay. Page number?
But page number 53.
The case is otherwise ready for hearing?
Yes, my lord.
Okay. LCR has
It is
come?
for final.
One IA is pending. Lord.
No, LCR has come?
No, no.
LCR has not been received so far.
Okay.
There is one IA. IA is for?
IA is for condonation of legal.
How much is the delay?
there is a delay of 173 days. I have not explained the delay in paragraph number 5 to 12. As because it
Have you
was-
filed any counter affidavit to the interlocutory application?
They have
No, my lord, because I was occupied in my marriage. So that was the reason I could not.
You see
compliant
this.
of
Let us delay the Let us condone the delay in filing the revision. It is better to take up the case on merits, isn't it? This is under 138.
my lord,
This is under 138.
no,
NI Act.
It is under
125.
120.
Yeah.
How much is the amount of maintenance fixed?
The amount of maintenance has been fixed at the rate of rupees 6,000.
5,000 for the respondent
5,000 for
that
the
is
wife
mother,
and
1,000 for the minor child.
Female child.
You say that at page number 60, OP did not appear to contest the case despite valid service of notice.
But in the order sheet itself, it has been observed that the notice was served to the brother, and admitted case of the OP is that at the relevant point of time he was residing at Ranchi, and notice was served otherwise on different address, and the brother could not.
What is your profession? What are you doing?
Profession, at present I am doing nothing,
Unemployed.
Unemployed, and he is
As per the order, what is your source of income? As per the impugned order.
as per the order, it has been assessed as
As per the impugned order, what is your source of income?
it has been observed that he is an BTech engineer, so that must have been income of rupees 25 to 30,000. It has been assessed, and this assessment is
From where do you say that the notice was served upon your brother?
from the order sheet, that is at page number 54.
54.
54 of my notes.
Yes.
Yes. From perusal of the case report, it appears that in this case, notice has already been served to the OP on dated 24 January 2020. The brother of the OP has received the notice on 24 January 2020. Service of summons notice is sufficient. Accordingly, OP is proceeded ex parte, which in this case on so and so.
Now you are aware of the matter.
Now I am aware, but practically, if there is no pleading,
Yes, certainly.
There is no pleading.
Certainly, we will take care of that. We will take care. What's your name, Mr. Counsel?
Advocate Gaurav Kumar.
Gaurav. Yes, Mr. Gaurav Kumar, there is an order placed on record by which the notice was served upon the brother. Now, if the impugned order is set aside on this ground, then both of you will have an opportunity to file your required affidavits in terms of Raziz versus Neha. Everything will come on surface. You may get better amount than what has been given by the court. There is a likelihood. We do not know. Because the petitioner appears to be a BTech engineer. He may be engaged somewhere, may not be engaged anywhere. Right? So on this ground, I think the matter is fit to be remanded back. And what do you say to this?
One submission from my side. The London court below issued notice on 6th of January 2020 prior to COVID, and 24th the notice was served to his brother who live in a share house. So he is aware about the.
That's right. He must be aware, but there is a technical problem. And notice to brother, if he is disputing, then we do not know. We will not take that as valid. And otherwise also the requirement of Neha versus Rajneesh is required to be satisfied. That affidavit has to be there. You also did not file your affidavit in terms of the said judgment.
But so I have also go through all the process again and again.
Not again and
We have
again.
already-
You see, we will fix a time frame, don't worry about it. So far as the quantified amount is concerned, he shall pay that amount subject to the final outcome of the, at least because it is not much that has been fixed. Yes,
No, it may be remanded.
it will be remanded. But the
Some-
whatever
some-
amount has been fixed,
Some
5,000,
amount-
7,000.
Some amount I have already paid, not as per our instruction.
So that amount will be adjusted. Whatever amount you have paid, you see, so far as current, let us forget about the past. So far as the current amount, whatever has been fixed by the learned court, you continue to pay as interim maintenance, and it will be subject to the final adjudication. It will be decided in 3 months' time. You go and appear, file your necessary affidavit in terms of the judgment of the Supreme Court. Right?
ये तो फाइनल अमाउंट फिक्स हुआ था,
कोई बात
इंट्रीम कर दिया जाएगा तो
कोई बात, you just wait and see. Final amount में तो पूरा back date से देना था, right?
But वो दे भी नहीं रहे हैं.
कोई बात
Problem
नहीं.
is that he is not paying the amount.
You pay that amount. It is a meager amount, not much.
But for Milord, me it is Milord excessive, and because I am unemployed.
अगर आप मतलब मैनुअल लेबर भी करेंगे ना, you will earn more than what?
उस लायक भी तो नहीं बचा।
क्यों आप मैनुअल इंजीनियर बन के क्या मैनुअल लेबर के लायक भी आदमी नहीं बचता है?
इंजीनियरिंग करने के बाद
कुछ नहीं करना है.
लेबर का काम करने के बंदे
Forget it. लिखिए. Criminal Revision Number 1362 of 2021. The learned counsel for the parties are present. This petition has been filed for the following relief. The learned counsel for the petitioner has referred to order dated 22/6/2021 passed by the learned family court to submit that the notice in the case was served upon his brother and not to him, and therefore the petitioner had no knowledge regarding the proceeding, which has resulted in passing of ex parte order. The learned counsel has also submitted that the petitioner is an unemployed person and the impugned order calls for interference. The learned counsel has also submitted that one opportunity be granted to the petitioner to appear before the impugned order be set aside, and one opportunity be granted to the petitioner to contest the case on merits before the learned family court. He has also submitted that the income of the petitioner, the income of the petitioner has been tentatively taken as rupees 25 to 30,000 per month while granting the maintenance, and in fact the petitioner is unemployed, though he is a BTech.
Yes.
The learned counsel for the opposite party, who has joined online, has opposed the prayer and has submitted that the petitioner and his brother were living under the same roof, and therefore the notice was accepted as validly served. The petitioner purposely did not participate in the proceedings. The learned counsel submits that the impugned order is a well-reasoned order, and only a meager amount of rupees 5,000 for the wife and rupees 1,000 for minor daughter has been awarded, and the order does not call for any interference. He has also submitted that the order of maintenance has been directed to be paid from the date of application, that is 3/1/2020. The learned, in response, the learned counsel for the petitioner has referred to a supplementary referred to the counter affidavit filed by the opposite party number 2 and 3 and has submitted that certain amount has been paid. इसी में है ना?
नहीं, इनका काउंटर नहीं है.
Okay. Has referred to your affidavit.
It is on instruction I am submitting.
Okay. The learned counsel, take it again. The learned counsel for the petitioner in response has submitted that the petitioner has been paying some or the other amount.
50,000 we have paid.
Has paid 50,000 to the opposite party on
27 जनवरी 23
on 27/1/2023.
and दो बार करके दिए गए. Date छोड़ दिया जाए.
In the year 2023?
Yes, yes. 23 में.
Just a moment. In the year 2023?
Yes.
Okay. In the year 2023. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, it is not in dispute that the petitioner is BTech. It is further not in dispute that opposite parties are, private opposite parties are the wife and daughter of the petitioner. In view of, from the perusal of order dated 22/6/2021 passed by the learned family court, it appears that the notice served upon the brother of the petitioner has been accepted as validly served and the proceeding was set ex parte. The service of notice upon the petitioner is being disputed by the petitioner. And the fact remains that the impugned order is an ex parte order, so far as the petitioner is concerned. Considering this aspect of the matter, considering the arguments advanced by the learned counsel for the parties, the impugned order dated 23/2/2022 calls for interference solely on the ground that the same is an ex parte order and the notice was accepted as validly served to the petitioner through his brother. The fact also remains that in terms of the judgment passed by the Honorable Supreme Court in the case of Raziz versus Neha reported in bracket 2021 bracket close 2 SCC 324, the required affidavits in terms of the enclosure 1, 2 and 3 of the said judgment were required to be filed even in all the pending proceedings for the purposes of assessment of the source of income of both the parties and to accordingly quantify the maintenance claimed by the wife/minor children. In the present case, even if the proceeding is taken in the present case, even if the proceeding was ex parte against the petitioner, the required affidavit was certainly to be filed by the wife. This court is of the considered view that the matter requires fresh consideration by the learned. It is district and sessions judge, not family court.
In the court, principal district and session judge come family judge.
Okay, by the court of principal district and sessions, principal district judge come family judge Ramgarh. after complying with the directions issued by the Honorable Supreme Court in the case of Raziz versus Neha. Accordingly, the impugned order is set aside to enable the learned court to pass fresh order in accordance with law. The parties are directed to appear before the learned court on 18th March. Will you appear?
Yes.
Yes.
On 18th of March 2024, along with their respective affidavit of disclosures in terms of the judgment passed in the case of Raziz versus Neha Supra. Upon their appearance, the learned court shall pass fresh order in accordance with law within a period of 3 months from the date of their appearance. It is further observed that so far as the maintenance amount fixed by the impugned order is concerned, the petitioner would continue to pay only the current maintenance amount in terms of the said order till the disposal of the matter by the learned court, and such payment will also be subject to the final outcome of the case. बढ़ा सकते हैं, घटा नहीं सकते. This petition is accordingly disposed of. There will be certain paragraphs from Raziz versus Neha. Kindly ensure that it is filed in terms of that affidavit, that requirement. Both of you. पढ़ लीजिए, देख लीजिए, पूरा डिटेल लिखा हुआ है.
इसमें कोट किया हुआ है रजनीश का, लेकिन
the affidavit of the parties should disclose their financial status right from the date of financial status, including the period from the date of filing of the case. I think there is a direction for 3 years prior to the date of filing application. I need to check. This last sentence will be subject to, I need to verify and then.
Item 7, Kiran Vision 1394 of 2022.
Because on the last day, we filed fresh notices for the respondent number 2 and 3 minutes. The first address that we provided in the petition, the notices could not be served, as the report came that the office has been shut 3 years ago. So we supplied fresh address notice on the last day. This is a case laws under section 138. I'm an original complainant. I'm only seeking laws enhancement of the compensation amount.
Okay, let us see the nature of the order, and then only there is a question of, let's have a look at it.
Please.
What enhancement? What was the check amount?
Because the check amount was 23 lakh rupees. It got dishonored on 18th of November 2017.
18
of November 2017. I filed a case under section 138 laws. The judgment came in my favor, convicting him for 1 year simple imprisonment along with payment of compensation for 23,50,000 on 29th of January 2020. That's the judgment of the learned trial.
What is the date?
It was 29th January 2020. That's the order of the learned magistrate.
Okay.
Thereafter, we both filed an appeal. He filed an appeal seeking reversal of his conviction. I filed an appeal seeking enhancement of compensation along with enhancement of punishment. The learned trial court said that since section 372 grants me only enhancement of compensation, or if the punishment is less, since the honorable court said that the punishment is adequate, I get a right only for the enhancement of compensation. So and the learned appellate could dismiss my application saying that I have not provided any reason as to why the amount is inadequate. Because against that order, I'm filing a revision before this honorable court saying that the check amount was 23 lakh. I've been only granted 50,000 rupees extra. There's one Supreme Court judgment in my favor which says that ordinarily twice the amount of check should be granted. And section 138
Ordinarily.
Ordinarily.
Which
That-
is that judgment? The opposite party, present opposite party, has not filed any cross revision or cross appeal.
It's not within our knowledge, my lords, because what has happened is that as per our instruction, my lords, the OP number 3 is in custody in some other case. Before the appellate court also, my lords, he was produced from custody before the Lok Adalat when the matter was being talked for settlement. And as per our present instruction also, we have that he might be still in custody.
So if he's still in custody, then how
That's
the
the
notice will be served upon
That's
him?
the difficulty, because there the company is also
You
accused.
take whatever money is being given to you. He might be in custody in connection with other check bouncing
But
case.
he's in Ramgarh PS case number 270 of 2018. So, my lords, if in case your lordship, my lords, if he's
It does
produced-
not really serve your purpose.
Yes, I agree.
You see, for 23 lakhs 50,000, you could have filed your recovery proceedings or whatever, because that has to be recovered as per the procedure of law.
Please,
His property could have been attached.
please.
He could have been put to jeopardy for not making. You are unnecessarily fighting.
My lords, we have not got even that amount so far.
So therefore, you have a remedy and a procedure to do it, but you are fighting for enhancement and you are not taking the money which has already been directed to be paid.
That's the difficulty is that there has been no offer from the other side as well.
You don't need to have an offer. You have to file your take steps as per the provision. It has to be realized as per fine, as per the procedure for realization of fine. His personal property will be attached. Does he have personal properties?
Because he has one company and he's a director of the company.
He must have, the company must
He's a
have gone
resident.
into liquidation by now.
Because he's a resident of Bihar. So, my lords, it's difficult for us to, my lords,
So that
verify
this
whether he's-
enhancement petition does not serve your purpose.
Because then I'll file a recovery for an enhanced amount. That is my lords.
So you will get nothing. Neither this amount nor the enhanced amount. And especially, you see, the impugned order does not, in revisional jurisdiction, there should be an error of law. What is the error of law in
It's
it?
my error.
And technically, this NI Act is not a recovery proceeding, isn't it? You file your suit.
I'll file a suit. My only difficulty that I contested a trial for 2 years. This 23 lakh I paid litigation cost. I suffered mental and economic
Must-
loss. So the
This is not a, you
50,000
see,
was
we don't
quite
have
less.
that, we don't have that procedure as is applicable in commercial courts, where the cost is assessed and then every penny is paid to the party, even if they do not accept the good offer in mediation, that is also taken into consideration. This is not, I'm not inclined that, otherwise you have to undertake paper publication. That will cost you another 10-20,000 rupees.
I'm ready to do
And at the end of the day, even if we proceed against him, you say that he is in custody. This order is 100% going to be citizen.
That is my difficulty. The another
So
difficulty
therefore,
that
no,
I've
we are not prima facie inclined to interfere with the order regarding your.
The Supreme Court says that.
The Supreme Court says, let us
Para
please say,
15 minutes.
para 15.
Should I read?
Yes.
Having reached that stage, if some magistrates go by the traditional view that the criminal proceedings are for imposing punishment on the accused, either imprisonment or fine or both, and there is no need to compensate the complainant, particularly if the complainant is not a victim in the real sense, but is a well-to-do financier or financial institution, difficulties and complications arise. In those cases where the discretion is to direct payment or compensation is not exercised, it causes considerable difficulty to the complainant, as invariably by the time of the criminal case is decided, the limitation for filing the civil cases would have expired. As per the provisions of Chapter 17 of the Act, strongly lean towards the grant of reimbursement of the loss by way of compensation. The court should, unless there are special circumstances, in all cases of conviction uniformly exercise the power to levy fine up to twice the check amount, keeping in view the check amount and simple interest thereupon at 9% per annum as a reasonable quantum of loss, and direct payment of such amount as compensation. The next page, direction to pay compensation by way of restitution in regard to the loss on account of dishonor of check should be practical and realistic, which would mean not only the payment of the check amount, but interest thereon at a reasonable rate. Uniformity and consistency in deciding similar cases by different courts not only increases the credibility of the check as a negotiable instrument, but the credibility of the courts of justice. So because in this case, even if I calculate 9% interest of 23 lakh, it comes around 2 lakh rupees. So that's my only prayer that 50,000 is it's a less amount of compensation that has been granted.
You just read para 16.
We are conscious of the fact that the proceedings under Section 138 of the Act cannot be treated as civil suits for recovery of the check amount with interest. We are also conscious of the fact that the compensation awarded under Section 357(1)(b) is not intended to be an elaborate exercise taking note of interest, etc. Our observations are necessitated due to the need to have a uniformity and consistency in decision making. In same time of check dishonor cases, after convicting the accused, if some court grant compensation and if some courts do not grant compensation, the inconsistency, though perfectly acceptable in the eye of law, will give rise to certain amount of uncertainty in the minds of litigants about the functioning of the courts. Citizens will not be able to arrange or regulate their affair in a proper manner as they will not know whether they should simultaneously file a civil suit or not. The problem is aggravated having regard to the fact that in spite of Section 143, subclause 3 of the Act, requiring the complaints in regard to check dishonor cases under Section 138 of the Act to be concluded within 6 months from the date of the filing of the complaint, such cases seldom reach finality before 3 or 4 years, let alone 6 months. These cases give rise to complications where civil suits have not been filed within 3 years on account of the pendency of the criminal cases. While it is not the duty of the criminal courts to ensure that successful complainants get the check amount also, it is their duty to have uniformity and consistency with the other courts dealing with similar cases. One other solution is a further amendment to the provision of Chapter 17 so that in all cases where there is a conviction, there should be a consequential levy of fine of an amount sufficient to cover the check amount and interest thereon at a fixed rate of 9% per annum interest, followed by award of such sum as compensation from the fine amount. This would lead to a uniformity in decisions, avoid multiplicity of proceedings, one for enforcing civil liability and another for enforcing criminal liability, and achieve the object of Chapter 17 of the Act, which is to increase the credibility of the instrument. This is, however, a matter of the Law Commission of India to consider. The appeal is thereby dismissed.
Where is the trial court's order?
The trial court order is the supplementary affidavit minutes I filed on 21st June 2023. The trial court order starts at page number 3 minutes. The sentencing part is at page number 10, which is the last page of the supplementary.
How much percentage of interest have you been granted?
There's no percentage of interest.
No, it is in terms of percentage, how much is the amount?
Because in terms of percentage, I have to calculate. 50,000 is the only.
What would be the quantum in terms of percentage?
Because I have to calculate. 9% says that it will be 2,07,000. I calculated 6% is also above 1 lakh. So that 50,000 is less than
You are calculating 9% per annum.
per annum. If I calculate 9%, then because it's 2,07,000 of 23 lakhs.
That's all?
This is my case. If your lordship may permit, I may.
No,
paper
nothing.
publication.
I've heard you. I'm not inclined to interfere in revision jurisdiction.
I see that I faced the contested trial for 2 years. I'm neither a financial
You are still contesting at your own peril.
My only submission is that if the complainant if they are only awarded such a small amount beyond the check amount, it also gives them a appearance that they can contest a suit.
You see,
therefore,
whenever any matter is being taken up in connection with Negotiable Instruments Act, you are also duty bound to produce certain judgments before the trial court, before the appellate court, isn't it? What assistance have you rendered to the court?
Because the Act says that.
The Act says compensation up to. It does not say twice. It says up to. So it is, and there are so many things. There could be delay and adjournments on your part, isn't it? You might have also taken time. Those foundational facts are not there. That the delay was wholly attributable to the court or wholly attributable to the opposite party is not coming from the records. Whatever there is no such pleading also that the delay was wholly attributable to the court or it was wholly attributable to the party.
I will only request your lordship and call for the LCR.
No, not required. Criminal revision number. No, that is. You have not made out a case to that effect.
Because even if
you have not made out a case to that effect.
Because even if this judgment, I go by this judgment of the Supreme Court.
It is not by way of default. I will deal with it. I will deal with it.
Say that I have to. There have to be.
I will certainly consider it. Don't worry about it. I will consider. It is not possible for me not to consider whatever judgments you are citing, right? Criminal appeal, sorry, just Criminal revision number 1394 of 2022. This revision application has been filed for the following relief. From the perusal of office note, it appears that undelivered registered cover upon opposite party number 2 and 3 has been received, stating that the recipient has left the mentioned address and the wife has refused to receive the notice. The learned counsel for the, and you are for OP?
State.
State. The learned counsel for the state is present. Heard the learned counsel for the petitioner on the merits of the case. The learned counsel for the petitioner has submitted that the petitioner is the complainant who had filed a petition under section 138 of Negotiable Instruments Act for relating to dishonor of check of rupees 23 lakhs on 15/11/2017. The notice, the legal notice was issued on 15/12/2017. And despite service of notice, the check amount was not paid. And consequently, a complaint case under section 138 of Negotiable Instruments Act was filed and was numbered as complaint case number 315 of 2018. The learned counsel submits that the complaint case remained pending and it was ultimately decided on 29/1/2020, and the accused were convicted, and there was a direction to pay the compensation of rupees 23,50,000 in terms of section 357 within bracket 3 CRPC. And with a further default clause. The learned counsel submits that the case remained pending before the court for almost 2 years, and therefore the compensation amount which was directed to be paid was inadequate. As per the provisions of law, the compensation amount which ought to have been paid was twice the check amount. He has relied upon a judgment passed by the Honorable Supreme Court, reported in, what is the citation?
That's AIR 2012,
SCC citation is there?
SC 5.
In AIR 2012 SC 528, and has referred to paragraph number 15 of the said judgment. 15, 16 and 17 of the said judgment. To submit that, the Honorable Supreme Court has held that in all cases of conviction, uniform exercise of power to levy fine up to twice the check amount, keeping in view the check amount and the simple interest thereon at the rate of 9% per annum as reasonable quantum of loss, should be awarded as compensation. The learned counsel has submitted that if 9% interest is taken into consideration, it comes to rupees 9 lakh
2,07,000.
2,07,000 per annum. Per annum?
per annum.
Are you sure?
Cross check it. I have only written 9%.
It comes to rupees 2,07,000. The learned counsel submits that arising out of the judgment passed by the learned trial court, an appeal was filed by both the parties. What is the appeal number of the other party?
Criminal appeal 42 of 2020. Disposed on the same date.
Criminal appeal
42 of 2020.
42 of 2020. So far as the opposite party is concerned, his appeal was numbered as Criminal Appeal 42 of 2020, which was dismissed on the very same day. And so far as the appeal of the present petitioner is concerned for enhancement of compensation, was numbered as Criminal Appeal number 37 of 2020, which has been dismissed on 8th day of September 2022. The learned counsel submits that the learned appellate court has refused to interfere by simply stating that the compensation amount of rupees 50,000 over and above rupees 23 lakhs being the check amount could not be shown to be arbitrary. The learned counsel submits that in view of the judgment passed by the Honorable Supreme Court, the compensation is inadequate and calls for interference. Are you opposing?
In appellate court order at page 20, para
Yes.
2, it has been said that it is not maintainable.
With regards to higher punishment, it said that is not maintainable.
Provision of section 372 CRPC have parents provision and the related appeal against any order by acquitting the accused or convicting lesser offence or imposing inadequate compensation.
Para number?
Para number 2 from court.
Page number
Page
20
number
of my
20.
revision.
Page number 20.
Of my revision petition.
Yes, page number 20 of your revision petition is internal page 5.
Yes,
of the-
internal page
Yes,
5.
Yes, para number?
So second paragraph.
Second
also.
one from court. Section 372 of CRPC have perused the provision and found that it is related to an appeal against any order passed by court acquitting the accused or convicting for a lesser offence or imposing inadequate compensation, and such appeal shall lie to High Court, to which an appeal ordinarily lies against the order of conviction of such court. In the above section, there is no power of to hear appeal in enhancement of punishment. Hence, I
No, this is not correct.
Not
This is not correct. After hearing the learned counsel for the state has submitted that the matter is between the petitioner and the complainant, and he has nothing to say. क्या बोलेंगे? You have not argued anything on merits.
merits में भी बोला कि rightly passed.
The learned counsel for the state has submitted that the impugned order has been rightly passed and does not call for any interference. He has also not indicated as to at whose instance the matter remained pending for 2 years. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that the complaint case was filed by the petitioner in the year 2018 and The inquiry was conducted by the court on 24/1/2018, and consequently process was issued against the accused. This date is correct?
Yes, madam, it's coming in the check.
Yes. The gist of accusation was explained to the accused on 21/3/2018, and the statement of the accused was recorded under section 313 on 9/1/2019. Thereafter, the accused also adduced 2 witnesses, and ultimately the learned trial court passed the judgment on 29/1/2020. Holding the accused guilty of the offence and directed for payment of compensation of rupees 23,50,000. A direction was also given for he was also sentenced. The convict Vishwajit Singh was also sentenced to undergo 1 year simple imprisonment for the offence. The appeal was filed by both the parties, and the appeal of the petitioner was numbered as criminal appeal number 37 of 2020. The appellate court was of the view that the appellate court recorded the finding in connection with enhancement of compensation as follows. Quote कर दीजिएगा, so far as the prayer for compensation is concerned. The petitioner in the present proceedings is only aggrieved by the quantum of compensation. In the judgment passed by the Honorable Supreme Court reported in AIR 2012 SC 528 Subhra, the Honorable Supreme Court has considered the provisions relating to compensation and has recorded that in those cases where the discretion to direct payment of compensation is not exercised, it causes considerable difficulty to the complainant, as invariably by the time the criminal case is decided, the limitation for filing civil cases would have expired. The Honorable Supreme Court was also of the view that the provision of Chapter Roman number 17 of the Act of CRPC, I suppose, of CRPC, strongly leans towards grant of reimbursement of the loss by way of compensation. And therefore the court should, unless there are special circumstances in all cases of conviction, uniformly exercise the power to levy fine up to twice the check amount within bracket, keeping in view the check amount and the simple interest thereon at the rate of 9% per annum as a reasonable quantum of loss, bracket close, and direct payment of such amount as compensation.
That's just one.
There is 15. It has also been observed that direction to pay compensation by way of restitution in regard to the loss on account of dishonor of check should be practical and realistic, which would mean not only the payment of the check amount but interest thereon as reasonable rate. It has been held that uniformity and consistency in deciding similar cases by different courts not only increase the credibility of the check as negotiable instruments but also the credibility of the courts of justice. The Honorable Supreme Court was also of the view that Section 138 of the Act cannot be treated as civil suit for recovery of check amount with interest, and compensation under Section 357 within bracket 1 within bracket B is not intended to be an elaborate exercise taking note of interest, etc. And the observations are necessitated due to the need to have uniformity and consistency in decision making. And in absence of such uniformity, there would be uncertainty in the mind of the litigants about the functioning of the court, and the citizens will not be able to arrange or regulate their affairs in proper manner, as they will not know whether they should simultaneously file a civil suit or not. The Honorable Supreme Court also observed that the case under Section 138 is to be concluded within 6 months from the date of filing the complaint, and such cases seldom reach finality before 3 or 4 years, let alone 6 months. These cases give rise to complications where civil suits have not been filed within 3 years on account of pendency of criminal case. It has been further observed that it is not the duty of the criminal court to ensure that successful complainants get the check amount also. It is their duty to have uniformity and consistency with other courts dealing with similar cases. This court finds that in the present case, the check is dated 15/11/2017, and the case has been decided within 3 years of the issuance of check. It is not a case where the criminal case remained pending for years together, and the remedy of the petitioner to avail further amount by way of civil suit has become barred by law. This court also finds that the petitioner has not given any detail in connection with the reason for adjournments of the case, whether it was taken at the instance of the petitioner or the accused persons, which can also be a ground for exercise of discretion in the matter of grant of compensation. Admittedly, the proceeding is not for recovery of money as is applicable under the civil suit. Recovery of money with interest as is applicable under the civil suit. This court is of the view that even if the petitioner was aggrieved by the quantum of compensation, the remedy to file the civil suit was still available to the petitioner upon the decision of the case. This court further finds that the appellate court, before the appellate court also, the petitioner, before the trial court as well as before the appellate court, the petitioner has not advanced any argument with regard to the quantum of compensation the petitioner, before the trial court, the petitioner did not advance any argument with regard to the quantum of compensation, and before the appellate court, the petitioner failed to show that the compensation was arbitrary. The appellate court was of the view that it was not just to interfere with the amount of compensation. Considering the totality of the facts and circumstances and the fact that the complaint case was decided much prior to expiry of the period of limitation within which the petitioner could have filed a suit for recovery of any additional amount, and also the fact that the foundational timeline in connection with the case as to whose instance the matter remained pending has neither been pleaded nor has been brought on record by the petitioner. This court finds no. This court is not inclined to interfere with the impugned order passed by the learned trial court as well as the appellate. Accordingly, this revision is hereby dismissed.
One submission that chapter 17 is of NII, it was not of CRPC.
Okay, chapter 17 is of NII.
And there was one submission that it was also the duty of the trial court to justify the compensation law. Does one of my submission have stated in my pleadings also?
I have just passed the order. After hearing you, that should be sufficient.
Because I did not interrupt your lordship.
Yes, that's
This is
right.
one of my
You have not
submission.
filed your suit for recovery of the balance amount.
I'm
Whatever
not saying that. It was my only one submission that it was also the
The
duty of
learned
trial
counsel,
court.
the learned counsel has submitted that the trial court ought to have suo moto exercise the judicial discretion in the matter of quantum of compensation
Provide reasoning for the
and no further assistance. Suo moto exercise the discretion. That should be
The
sufficient.
trial court should provide reasoning for giving a compensation.
Okay.
That's my.
The learned counsel has submitted that. ऊपर लिख दीजिएगा. I will just record. The trial court has not cited reasons with regard to quantification of the compensation amount. That in your submission it will be recorded. चलिए next.
Household case item 1, WPC 1450 of 2014.
I will just cite a judgment on scope of revisional jurisdiction, because there is a judgment which says that in all cases revisional jurisdiction need not be exercised, even if there is some irregularity. Right? I will just cite that judgment. You have not brought it, I will cite it. Yes, petitioner?
Yes, sir.
We have filed a rejoinder to the counter affidavit, wherein we have stated everything. Your Lordship may please just have a look to paragraph 11 and thereafter.
You argue your case fully. I am hearing it.
Granted to my counter affidavit has been filed, but the bank has till date not filed.
Let them not file it, we don't bother about it. Argue your case. They have chosen not to file, that is their problem.
We have come before this honorable court, your lordship, with a humble prayer that the amount which was to be given to the farmers, your lordship, to the tune of 31 crores. Out
Give
of
the exact figure.
Yes, your lordship. That exact figure is
Here is the list of dates. The figure and facts all are listed.
When was the loan disbursed?
The scheme is
When was the loan disbursed? I am getting the dates of waiver claim.
Waiver
When was
claim.
the loan disbursed?
loan disbursed up to 2007 that has to be waived.
Okay.
Or relief
That's-
has to be given. Small and marginal farmer waiver and
That's-
other farmers relief.
The entire loan amount was funded by NABARD.
No. Loan disbursed by the district cooperative bank.
Fund was received by whom? From whom?
I received from the central government.
From
and
central government through NABARD.
I am NABARD. NABARD received this amount from the central government for disbursement for waiver to compensate.
Waiver is another thing.
Right, to compensate the bank, not to directly give to the farmers, to compensate the bank who waives the loan amount of the farmers.
But the loan was disbursed by the bank from
Bank.
their own funds.
From their own funds
Okay.
prior to that. Thereafter the scheme came, 2008.
That's right.
So my preliminary objection is also here that
No,
he
you
has
don't need to. Please, we will hear everything. Let the petitioner finish, then we will hear. Yes, Mr. Tiwari, you continue.
yes, your lordship.
I'm hearing you.
Your lordship, may please just have a look to paragraph number 5 and thereafter.
You just argue. I have read the brief. You will argue your case. You can just argue.
Under this scheme, your lordship, loan waiver was to be given to the farmers. For that, a list was to be prepared on the directions which I have already given in my counter affidavit, your lordship. The list was prepared. Subsequently, it was audited according to the procedures laid down in the cooperative department, your lordship. Everything was done. Thereafter, if your lordship please just allow me only to point out the annexure R by 1, that is at page number 14 of the rejoinder. This is the procedure by which the list of the farmers who are eligible to get the loan waiver, your lordship, that was prepared. Please allow me only to point out the relevant portion. That is at page number 14, 21/6/2008. Paragraph 2. लैम्प्स पैक्स द्वारा अपने स्रोत से वितरित कृषि ऋण की सूची संबंधित सदस्य सचिव प्रभारी सहकारिता प्रसार पदाधिकारी द्वारा तैयार किया जाएगा। इस प्रकार तैयार सूची की जांच संबंधित सैम पैक्स के अक्षेक्षण हेतु प्रतिनियुक्त अक्षेक्षण पदाधिकारी द्वारा किया जाएगा। सभी लैम्प्स पैक्स की सूची को जिला स्तर पर समेकित किया जाएगा, जिसकी 100% जांच जिला सहकारिता पदाधिकारियों द्वारा कर उसे सत्यापित किया जाएगा एवं उसकी जिला क्षेत्र पदाधिकारी द्वारा भी किया जाएगा। सूची के 10% प्रतिवादी की जांच प्रबंध निर्देशक के द्वारा भी किया जाएगा। ऋण माफी, ऋण राहत से संबंधित सूची का सत्यापन संबंधित पदाधिकारियों द्वारा दिनांक 30/6/2008 के पूर्व निश्चित रूप से कर लिया जाएगा। एंड दिस इज इम्पोर्टेंट, पैराग्राफ 3। प्रत्येक बैंक के शाखा एवं लैंप्स पैक्स के सूचना पट पर दिनांक 30/6/2008 तक निश्चित रूप से ऐसे कृषकों की सूची प्रदर्शित की जाएगी जिनका ऋण माफ किया गया है या जिन्हें ऋण राहत दिया गया है। 30/6/2008 तक सभी कृषकों जिनका ऋण माफ किया गया है को नाबार्ड रांची के पत्रांक 783 डेटेड 18/6/2008 द्वारा प्रेषित ऋण माफी से संबंधित प्रमाण पत्र दिया जाएगा। प्रमाण पत्र में नाबार्ड का पत्रांक 784 डेटेड 18/6/2008 द्वारा प्रेषित माननीय प्रधानमंत्री का संदेश का छाया प्रति संलग्न रहेगा। अतः आपको निर्देश दिया जाता है कि आप नाबार्ड द्वारा दिए गए निर्देश के आलोक में निर्धारित समय सीमा के अंदर आवश्यक कार्रवाई करते हुए नाबार्ड को प्रतिवेदन समर्पित करना सुनिश्चित करें एवं प्रतिवेदन की प्रति इस कार्यालय को भी दी जाए। Thereafter, your lordship, according to the procedure of audit, random sample, a list of the eligible farmers who are to be given the benefit of that loan waiver that was prepared. And according to clause 7.1 of the scheme, 71 packs, that is Primary Agriculture Credit Cooperative Society, submitted the list of loanee farmers who were entitled for the benefits under the scheme. That these lists were prepared jointly by the block cooperative extension officer and the manager/chairman of the respective packs. That the said list prepared jointly as stated above were to be audited 100% audited by the auditor of the cooperative department. That as such all these lists prepared were audited by the competent authorities, that is the auditor of the cooperative department, and finding it to be satisfactory and genuine, and it was sent to the competent authorities of the Dhanbad Central Cooperative Bank. That it was also necessary that a random inquiry at least of 10% of the members eligible to get the benefits of the said scheme was to be done jointly by the managing director of the Dhanbad Central Cooperative Bank as well as the district cooperative officers of the respective districts. That after fulfilling all these requirements as stated above, the list was finally sent to the NABARD through the Dhanbad Central Cooperative Bank. That according to the list submitted by the different packs through the Dhanbad Central Cooperative Bank, the farmers entitled for the said benefits under the scheme was calculated to the tune of rupees 31 crores approximately.
Give the exact figure, please.
30 crores 92 lakhs 15,300. $30 crores 92 lakhs 15,300. Out of which 17 crores 44 lakhs 88,000 was given by the NABARD to the Dhanbad Central Cooperative Bank. We have come before this honorable court with a humble prayer that the rest of the amount, that is 30 crores 92 lakhs 15,300 minus 17 crores 44 lakhs 88,000 should be given to the bank, as because the loan waiver has already been given to the farmers to the tune of that is why we have come before this honorable court, that this rest of the amount that should be given to us because it has already been distributed among the farmers. Now your lordship will please see, there was a unknown complaint made by some
No,
person.
just a minute. Where do you say that this waiver has already been given?
Yes, your lordship. That is our main case.
Where is it?
Your lordship will please see. Your lordship may please see paragraph 9
Of the writ petition?
of the writ petition. May I read it, your lordship? That the Dhanbad Central Cooperative Bank Limited, for short hereinafter referred to the Dhanbad CCB, submitted a claim of rupees 3 crores and 30 crores and something to NABARD under the said scheme, which included the claim forwarded to Dhanbad CCB by 78 numbers of packs affiliated to it, against which an amount of rupees 17 crores 44 lakhs 88,000 was initially released to the Dhanbad CCB by NABARD. But however, thereafter when NABARD, on receipt of an unanimous complaint, carried out a study to assess the proper implementation of the said scheme by the Dhanbad CCB, it detected some irregularities in its implementation with respect to a particular PAX. That it may be stated that the...
So you just come to the straight away to the statement that the relief to the farmers has already been conferred and you are only seeking reimbursement.
Yes, your lordship.
Show it, kindly show it from the records. From your pleading, show it somewhere it is there. ये दूसरा कलर का भी ये चाहिए. All 4 colors should be here.
Now, your lordship, the complaint that was given by the unknown...
Please don't skip the question. Either you say it is there or you say it is not there.
It is there.
Kindly show me the statement.
Yes, your lordship, it is there. Paragraph 7, your lordship.
Yes.
It starts from paragraph 6. That the petitioner number 1 and petitioner number 2 in the instant writ petition are aggrieved by and therefore are challenging the act of the National Bank of Agriculture and Rural Development, for short NABARD, in withholding payment of the debt waiver relief amount to the eligible farmers, beneficiaries of their respective packs, granted to them by the government of India.
That's right. Granted is a scheme.
No, we have already granted it.
From where do I get this? Show it from your pleadings.
Please
that-
allow me to read the statements. Everything is there.
No, you ask your junior to read it and you can continue by that time. Because I could not find that statement. I have read it. I'm sure that he will be in a position to point it out. You can continue. Let us take your statement as correct and then proceed. आप खाली पैराग्राफ नंबर बता देंगे, हम उसको नोट करें. बताइए. आगे बहस करें.
Now, your lordship, there is a scheme that these farmers will be given the benefit of that loan.
How many packs are there? 71.
78.
78.
78 packs.
Okay. You are only 2 packs.
Representing, your lordship.
No, you cannot file a case in a representative capacity on behalf of all the packs. You are representing only 2 packs.
Please see our statement.
Yes.
Please
Have
see.
they authorized you to file this case on
Yes,
their behalf also?
Yes, we have also stated that. In categorical words, we have stated.
Para 5.
And also on behalf of 51 other similar packs, having been duly authorized by the representatives of the said 51 packs in the meeting held on 9/2/2014. On the basis of that, we have come before this honorable court. Thereafter, your lordship, paragraph 6, 7, 8, what your lordship is asking, that has been clearly mentioned.
I will just take it down. Para 6, 7 and
8.
now continue.
9 also, your lordship.
8 and 9. Okay.
And
Continue.
thereafter, paragraph 10 says, your lordship, that it may be stated that the Principal Central Accountant General Audit Jharkhand Ranchi was short CAG undertook a performance audit of the debt waiver relief granted under this 2008 across the country, and in course of the same undertook for performance audit of 3 central cooperative banks in the state of Jharkhand, which included the Dhanbad CCB.
That's
In course of the performance audit undertaken by the CAG, it detected irregularities committed by the lending institutions in implementing
this performance audit was in relation to waiver or it was in relation to release of loan?
No, waiver.
Okay.
And then it came to the conclusion that some irregularities have been committed by the lending institutions. That is called ineligible amounts that were given. That I have stated in my rejoinder, your lordship. Please allow me only to point out annexure R2. What is this ineligible amount? That is, this amount has been paid in excess to the bank for loan waivers of the persons who are not eligible to accept that, who are not eligible under that benefit scheme, your lordship. Please just come to annexure R2 of my rejoinder. And that I have stated. Your lordship, at paragraph 21 of my rejoinder, that immediately the Controller and Auditor General, CAG, while letter dated 20th June 2013, was pleased to intimate to the administrator, Dhanbad Central Cooperative Bank Limited, that the DCCB was required to refund the total amount of rupees 44,66,111. Against this refund, rupees 17,59,836 have been made, and the balance amount of rupees 27,06,025 is required to be refunded. But now, your lordship, nearly 97 lakhs have been refunded by the DCCB. Although the Controller and Auditor General, your lordship, wanted that rupees 44,66,000 should be refunded as ineligible amount. Your lordship, may please allow me to read that. As indicated in the final report of the Controller and Auditor General, CAG, regarding performance audit of banks under ADWDRS 2008, the Dhanbad Central Cooperative Bank was required to refund total amount of rupees 44,66,111, against which it has refunded only rupees 17,59,836 so far. We have issued several letters, reminders to the bank in this regard. However, we have not received the balance amount of rupees 27,06,275. As the matter is before the Public Accounts Committee of the Parliament and it is being reviewed by the Finance Minister, Government of India, The refund due in respect of irregularities pointed out in audit by CAG is to be made to NABARD immediately. In case the bank has any reservation objection, the bank can very well submit this same to us for taking up with Government of India. We therefore request you to intervene and impress upon the bank to refund the balance amount of rupees 27 lakhs 6,275 to us immediately, latest by 21st June 2013. And thereafter, Your Lordship, this amount rose to 1 crore 47 lakhs, out of which nearly 97 lakhs has already been refunded, and 47 lakhs is to be refunded by the Dhanbad Central Cooperative Bank. But the NABARD is to pay rupees 30 crores and odd, which I have just submitted to Your Lordship, out of which only 17 crores have been paid, and loan waiver to the farmers have already been given by the PACs. Because, Your Lordship, in every meeting, farmers assemble. Thereafter, Your Lordship, these certificates are given by the competent authorities of the government. That is, it is the cooperative officer, it is the MLA, it is the member of parliament. All these persons, they gather, Your Lordship, and they give a certificate that X is entitled to a loan waiver of rupees 10. This certificate is being granted to him, and his loan of rupees 10, which has been taken, that will be paid by the NABARD through the DCCB. And Dhanbad Central Cooperative Bank, Your Lordship, gave the list of all such farmers of 78 packs, which was formulated on the basis of the procedure that was laid down. There is an audit done by this organization, audit done by that organization, thereafter CAG's report, subsequently, Your Lordship, the loan waiver, and that list is also given. Your Lordship will please see, we have also given the list. That is also there. Please just come to Annexure R3. While letter dated 12/11/2013, the in charge officer, Your Lordship, Lekha Niyantrak Karyalay with Vibhag Rajkiya Mudralay, Parisad Lorenda Ranchi, he writes to the Prabandh Nirdesak, Central Cooperative Bank Dhanbad, wherein the audit report, Your Lordship, of 5/2013-14 has been given, wherein everything has been discussed, Your Lordship. Who are the persons? Please just come to page number 18. अंकेचित लेखा का नाम ADWDRS 2008 से संबंधित सेंट्रल कोऑपरेटिव बैंक धनबाद के पैक्सों एवं शाखाओं का अंकेक्षण. दिस इज ऑडिट. प्रबंध निर्देशक, everything has been given in details. Thereafter, please just come to page number 19, the second paragraph. धनबाद सेंट्रल कोऑपरेटिव बैंक धनबाद द्वारा नाबार्ड रांची नोडल एजेंसी को ऋण माफी राहत हेतु रुपीस 30,92,15,300 का दावा प्रेषित किया गया था, जिसके विरुद्ध अभी तक धनबाद सेंट्रल कोऑपरेटिव बैंक को रुपीस 17,44,44,88,000 प्राप्त हुआ है, जिसे विभिन्न बैंक शाखाओं एवं पैक्सों को वितरित कर दिया गया है. विवरण प्रतिवेदन के परिशिष्ट अ पर उल्लेखित है. नाबार्ड एवं सहकारिता विभाग झारखंड रांची के दिशा निर्देश एवं नियमों के अनुसार विभिन्न पैक्सों एवं बैंक शाखाओं द्वारा तैयार ऋण माफी राहत दावा सूची को प्रखंड सहकारिता प्रसार पदाधिकारी, अंकेक्षण पदाधिकारी, जिला अंकेक्षण पदाधिकारी, जिला सहकारिता पदाधिकारी एवं प्रबंध निर्देशक सहकारिता बैंक द्वारा जांच एवं सत्यापित कर बैंक स्तर पर समेकित कर नाबार्ड को दावा प्रेषित करना था। उल्लेखनीय है कि नाबार्ड एवं सहकारिता विभाग झारखंड रांची के निर्देशानुसार पैक्सों को केवल कृषि ऋण की माफी का दावा बैंक को भेजना था, लेकिन कुछ पैक्सों के द्वारा गैर कृषि ऋण एवं मानक तिथि के विपरीत दावा प्रस्तुत किया गया। कुछ पैक्सों के दावा सूची पर पदाधिकारी के टिप्पणी पर लिप्त लेखन पाया गया, तो कुछ पैक्सों के दावा सूची पर प्रतिकूल टिप्पणी को काटकर अनुकूल टिप्पणी अंकित था। ऋण माफी प्रमाण पत्र सभी किसानों के बीच वितरित नहीं होने के कारण कुछ किसानों से ऋण माफी होने के उपरांत भी ऋण राशि की वसूली पाई गई। विस्तृत विवरणी कंडिका में उल्लेखित है। Thereafter everything has been given your lordship. This is it of the year 2013-14. The list of all the farmers who were given the benefit of that, your lordship, starts from page number 27 and thereafter. And we have come before this honorable court, your lordship, only with a humble prayer that the rest of the amount which is lying, that should be made paid, so that whatever loan has been waived of the farmers, that can be compensated. Your lordship may please then just come to annexure 4. This is the letter by which the ineligible amount that has already been returned. This is of 18/2/2021.
From where do you get ineligible amount when only part amount has been disbursed?
Yes, your lordship, that is in the report of that
No, from where do you get this
CAG
ineligible
report,
amount?
CAG report. The report which I have just shown to your lordship, annexure R2.
The total
What?
of this amount is this much.
Ineligible. That means
That amounts to how much?
that amounts to 1 crore 47 lakhs. Out of which, your lordship, this has already been given 97 lakhs 47,595. That
This figure does not appear to be correct. If you see the calculator, दीजिए sir. Page number 19 of your rejoinder. This is 38,80,561, which is ineligible.
No, this is the total amount that was to be given. 30 crores 92 lakhs 15,003.
See, with each of the figure, there is a reason for not granting the amount.
That has never been given. That has never been given.
So therefore, if it has not been given, then you are claiming against this only.
Yes, your
Out of 30 crore, 17 crore has been paid. You are claiming the remaining. But with regard to the rest, there is a reason for not disbursing that amount. Each one of it has been mentioned in page number 19 onwards. 38 lakhs, then you have 16 lakhs, then you have 53 lakhs, then you have 1,64,000, then you have 37 lakhs, then you have 3,56,000, 5,58,000, 19,68,000, 1,77,000. Everything is mentioned.
Yes, that comes to 1 crore 47 lakhs.
How is it 1 crore 47
Yes, your
lakhs?
lordship, please allow me only to point out. I have stated.
38 plus 16 is how much? So 38 plus 17 plus 53.
Yes, your lordship.
It comes to only 1,47,000.
Yes, your
How much
lordship.
does it come to? Calculate करके बताइए कितना है इनका अमान्य राशि.
Paragraph
We will take it. According to you, how much does it come to? 1
paragraph
crore?
22 I have given.
No, you just give us the total.
Yes, your lordship.
According to you, how much it is?
1 crore 47 lakhs 53,778.
778. Okay. The total at page number 19 onwards.
And paragraph 22 of my rejoinder. And out of this 1 crore 47 lakhs 53,778, 97 lakhs have already been refunded.
That's right.
That is annexure 4. And another 47 or 50 lakhs is to be given by the DCCB under the head ineligible amount.
That's right.
These amounts, your lordship, out of that 17 crores, that it says that it has been...
You see, there are two things. One is 30 crores was the total amount. 17 crores was disbursed. You are claiming for the differential. If the differential was not paid, then under such circumstances there is no question of refund of differential. So what has been refunded is a part amount of 17 crores.
Yes. And the rest of the amount, 30 minus 17, that loan waiver has already been given to the eligible farmers. And that NABARD has to pay, your lordship, to the bank.
We will see that.
Under that scheme.
Bank is not asking for money.
Yes, bank is also asking for money.
No, bank is not the petitioner before us. They don't even file a counter affidavit. They don't even file an affidavit supporting you. So you cannot argue for the bank. You can argue only for yourself.
Your lordship, through the bank, the entire farmers
They are not
benefited.
bothered about it. They are not interested in any money. They are more than what they require. So please hold on. Hold on. Please, I'm not called upon you so far. That is all?
Your
You
lordship,
want to argue anything more?
Yes, your lordship. Paragraph 22, 23, 24 and 25 of my rejoinder. Please allow me only to read that. And that is the whole crux of the matter.
Para 22 to 25.
25.
That's right.
On the basis of the audit done by the Finance Department of the Government of Jharkhand, of all the 78 packs, then it came, your lordship, on the basis which the letter number 71 dated 12/11/2013, that an amount of rupees 1,47,53,778 was the ineligible amount which was paid by the NABARD to the bank. And this was to be returned by the bank to the NABARD, out of which, your lordship, annexure 4, 97 lakhs have already been, because we have annexed, your lordship, the list of all the persons, the members who were given the benefit of that loan waiver. What is the amount right from page 29? This is item number 1, page 29. Chanda packs, Chandan Kyari. Your lordship.
Page 29.
Page 29.
29 is no something else. I don't get it.
Page 20.
Immediately after the report, there is Ankekshan
प्रतिवेदन की खंडिका एक से संबंधित प्रस्तुत एवं अप्रस्तुत अभिलेखों की सूची. All these सूचीज are there. Then, your lordship, may please turn to the next page.
It is absolutely illegible. Anyways, you have filed it for the first time in counter rejoinder.
No, we have filed it there also. In the writ also we have.
So you read it from the writ petition. Why do you need to read it from the rejoinder?
Please just come to page number 102. Annexure 12.
The documents which are already on record, you have filed it in rejoinder also.
Yes, your lordship, because only to point out that what is the amount that.
No, I want to know that things which are already there in the writ petition, you file it again in the rejoinder.
Your lordship will please just come to page number 102. This is.
After page number 94, I have page number 108. Yes. What do you want to say?
Your lordship, this is annexure R. Persist R अक्षेचन प्रतिवेदन की कंडिका से संबंधित ADWRAD 2008 से संबंधित ऋण माफी दावा एवं प्राप्ति राशि की विवरणी. And in 5 columns, your lordship, everything has been given. This is Chas Sakha, Pax number, Pax का नाम KCC. This is Kisan, that नाबार्ड से प्रसिद्ध ऋण माफी राहत दावा KCC. नाबार्ड से प्राप्त दावा राशि. This is the शेष राशि. Everything has been given by the concerned Pax. Thereafter, your lordship, audited by the competent authorities of the government of the particular department, sent to the DCCB. Thereafter, your lordship, sent to the NABARD, making a claim of the entire amount, and already these amounts as loan waiver, the certificates have already been granted to the farmers by the authorities of the PAX along with the authorities of the government. In
That the
different
loan has been waived, that certificate that there is no due certificate has been given to them.
to the farmers.
From where do I get one sample no due certificate?
And thereafter, your lordship, this amount was to be reimbursed by the NABARD to the bank. And that they have, your lordship, admitted in their counter affidavit.
So all the persons in connection with which you are talking about waiver, those are real persons?
Yes, your lordship. Save and accept 1 crore 47 lakhs.
So you can identify all of them?
Yes.
They can come?
Yes. Yes. Out of these 56 packs for which?
Not only 56 packs.
78.
Each person
Yes,
individually.
yes, yes. A person who has taken the
Loan
benefit, he
has
will
to
come
come.
and produce the certificate.
Not the certificate. Produce a document regarding his loan and then waiver.
Yes, sir.
Unless the loan has been disbursed, there is no question of waiver.
Yes, yes,
Isn't it?
yes. They will come.
Respondent?
Yes, because NABARD has to ensure that the loan waiver scheme, the amount should be given to the eligible person.
That's right. That is your concern.
Yes, Your Lordship. So when the list of farmers, eligible farmers was given by the district cooperative bank, amounting to ₹30 crores and odds, I have released 17 crores. Then on complaint, when audit was done by the cooperative
What was the
department-
nature of complaint? It is not there on record.
Yes, also that is not on record, but two inquiry was conducted, 2 audit was conducted, one by the cooperative department and by the CAG. Cooperative department, the annexure 12, if your lordship will see, annexure 12, I have the scheme also, I have annexed the scheme, I will show the scheme also. Who are the person eligible? The scheme say
वो टोटल की है आप कितना है?
हाँ टोटल वही हम बता दे रहे हैं 3 करोड़ के आसपास आता है इसलिए कि एनेक्सर 12 योर लॉर्डशिप में काइंडली हैव अ लुक एट एनेक्सर 12 once more ये पारा 2 में पेज 93 में कहते हैं कि 38,80,561 दावा अमान्य है। उसके बाद 3 में है 16 लाख दावा अमान्य है। सब हम जोड़ रहे हैं।
Yes, sir.
उसके
I've
बाद
seen that.
4 में 53 लाख इतना दावा अमान्य है। उसके बाद 1 करोड़ 64 लाख अधिक सूद माफी का दावा अमान्य है। उसके बाद 37 लाख 83,000 ये भी दावा अमान्य है। उसके बाद 3 करोड़ 56 लाख लाभुकों से वसूली गई राशि वापस करने योग्य है। ये जबरदस्ती कर लिए है these are the irregularities.
Internal page 25 में आइए of that report. मतलब rejoinder के page 25.
Rejoinder, yes.
पर ये इस प्रकार स्थिति स्पष्ट होने तक 17 करोड़ 20 लाख रुपए आपत्ति अंतर्गत रखा जाता है।
तो 17 करोड़ जो दिए 17 करोड़ तो आपत्ति में है। जितना हम पैसा दिए हैं
जब तक उसका प्रॉपर यूटिलाइजेशन का नहीं मिलेगा तब तक फर्दर रिलीज कैसे होगा? यही है कहानी।
यही कहानी।
बैंक को क्या बोलना है?
Bank will say that all these banks are affiliated to me. They have waived the loan under the scheme and they have given me the account. I have only the intermediary agent.
No, you have not. You see, you cannot say anything which you have not brought on record. Lecture नहीं चाहिए हम लोग को. Record से दिखाइए that the entire amount of loan has been waived and they have been issued no due certificate. Now everything will fall on you. Show us from the record.
I have not filed.
You see, the question of waiver does not arise normally unless the fund is received. This is the normal banking procedure, isn't it?
My role is only intermediary agent. I get the money, I pass the money to the PAX members. Nothing more, nothing less. What I say, members, that
the 17 lakhs has been passed to PAX.
Passed to PAX.
From where do I get this?
Because
आप हमको बताइए from where do I get this? You have not filed any counter affidavit.
Government in the writ petition.
No, where is that government?
Writ petition is
No,
not
please don't. You are in 226. You have to answer the query of this court. Right? Where is it that this 17 lakhs has been passed over to the PAX and this 17 crore has been ultimately utilized as loan waiver and no due certificate has been issued. Unless no due certificate is issued, there is no question of any waiver.
Their account has been written off. That account they have given to us. We are only the passing agent.
And so far as 17 crores is concerned, that is also under doubt. That is also under cloud.
That was the audit committed by the government.
So government has a right to commit.
Certain portion of the wrong was given and to the extent that we have refunded.
Why are you refunding?
Because to that extent,
what is the reason for refund?
Because to the extent the objection was made, and
the objection is to the extent of rupees 172.
That was we are correspondingly asking.
You could have said that okay, this is the objection. We want to utilize it in some other.
No, whatever we are doing, the objection came. We pass it on to the PAX. PAX refunded it. Then we are passing it on. We are only making a
Are your whatever amount you have received? Have you received a clean chit of the receipted amount? Have you? You see, my question is very specific. Whatever amount you have received, have you received a clean chit in connection with utilization of that amount?
The PAX have submitted to us that we have written
from NABARD. We are talking about NABARD.
NABARD has got independent inquiry done. Certain wrongs they found. We have passed on to the PAX. PAX refunded it. We pass it on.
PAX also refunded it to you.
We are only lost.
So you cannot say that 17 lakhs has been utilized to write off the loan because PAX has returned it to you.
To the extent the objection is there, that is adjusted. The rest of the amount they are asking for, and it is outstanding in the account of the PAX because they have written off the entire loan amount. They are saying that since we have written off the entire loan amount from our account, that is still the 50% of that is still holding balance. Therefore, they are asking for that.
How many beneficiaries are there?
Total. Total that has to call for from the 78 PAX number of beneficiaries.
You also are not aware. You are disbursing money. You are the conduit, and you are not aware how many beneficiaries are there.
Detailed chain process was for that. They are submitting it out after audit report,
You
etc.
see,
We are doing this. I have asked them from the detailed viewers. They said that we are supporting the petition. It is not that I have not. But they are saying we are in support of that. Lordship so much said because
nothing.
One order Lordship because see, my Lord has said that you will file the affidavit in the line of the petitioner Alice, is this order dated 13
No, you,
23.
it is your choice, whatever you want to
No,
file.
sir, say the letter counsel for
Counter
the
affidavit, filing of counter
So I also
affidavit
filed
is your
affidavit in
choice.
the aforesaid line. That is line was they have filed. See, the same thing they have come to me with the same thing. I said why to repeat make the file bulky.
Is there any order depriving you from filing a counter
They to
affidavit?
submit, my lord, the same document that they have filed, they have brought to us. I said why to just repeat the things.
Fair
Same affidavit, same document. I have seen that document, my lord. And the lord's direction was to file in the same line. Only a repetition of the affidavit. This is what the order was, and I said that you can file same document, same affidavit, same statement.
That's all.
At page number 25, your lordship has read. इस प्रकार स्थिति स्पष्ट होने तक रुपये 17 करोड़ 20 लाख 9,204 आपत्तिगत रखा जाता है। अक्षेषण का सुझाव है कि बैंक अपने स्तर इसकी जांच कर सुनिश्चित हो ले कि उक्त ऋण माफी योग्य है या नहीं। It is not that it has not been given to the farmers or anything like that. It is in doubt. So a audit has to be done. Only to that extent, your lordship. And the waiver that has been given to the farmers, your lordship, they have all been provided with the certificates.
Certificate, no due certificate.
Yes.
From where do I get this? And this audit report is dated 12/11/2013. Right? Prior to issuance of this audit report, substantial amount till 24/6/2013 was already released by the bank to the NABARD. 16 lakhs, 4 lakhs, 27 lakhs was already refunded.
No, they had already stated in the CAG audit observation, your lordship, the Dhanbad Central Cooperative Bank was to refund 44,66,111 according to the CAG audit observation. Out of that, your lordship, 17 lakhs were refunded, and rest of the 27 lakhs that was to be refunded. And subsequently, the amount of ineligible amount that came to about 1 crore 47 lakhs. Out of that also, your lordship, 97 lakhs has already been returned by the bank to the NABARD. Now, about 50 lakhs is to be refunded. And as far as we are concerned, your lordship, we are praying that not a single person who was not eligible has been given the loan waiver benefit. So, the rest of the amount of 30 crores, 13 crores or 14 crores, whatever it is, your lordship, that should immediately be released by NABARD to the bank. As because already the benefits have been extended to all the farmers who are eligible to receive the same. Para 29,
I've heard it.
Para 29, your lordship, may please allow
So
me.
you just tell us, you have said that loan waiver has been given to the farmers. You initially referred to para 6 to 10. Now you are referring to para number 29?
25, 20, yes, your lordship.
Which all paragraph, tell us?
Yes, your lordship. Please allow me. Uh, 6 to 10, your lordship, I have already.
Yes.
6 to 10, I have already said. Then, your lordship, paragraph 11 also says about the CAG audit.
You just
of the
refer to the paragraphs.
Paragraph 11.
11. 6 to 10 and 11 are required to be seen
No,
for your amendment.
More.
Yes, which all paragraphs?
Yes, your lordship. And we have stated in paragraph 12 that all the large number of rightful beneficiaries had already been issued loan waiver certificates. That your lordship was asking in which paragraph it has been given. We have stated, your lordship, that remedy to the problem, since a large number of rightful beneficiaries had already been issued the loan waiver certificates. The remedy lay in undertaking a proper exercise to identify and correct the errors and thereby honor the award 2008 scheme of the Government of India for the benefit of the rightful beneficiaries. That it paragraph 12, thereafter 13, Your Lordship. That at this stage it is necessary to identify and submit some of the causes which led to the occurrence of irregularities. That has also been given at paragraph number 13. Subsequent to that, Your Lordship, everything we have in details given as to what some minor irregularities which were committed, and that has been pointed out to Your Lordship, and that we have also given to the NABARD also. Paragraph 14, Your Lordship, on the instruction, letter number 568 dated 4/7/2008. Entire exercise of screening, checking, auditing of the claim applications were again done before submission of the claims to NABARD. According to the letter number 568 dated 4/7/2008, a series of procedures were gone into, and subsequently, Your Lordship, before submission of the claims, everything which we have done, that also we have categorically stated. And the role of the bank, Your Lordship, is mentioned at paragraph number 15. What role does the bank do while the PACs enter into waiving out?
Mr. Mahesh Devadi, I have heard you. My specific query and specific paragraph I want. So you just tell us that which all paragraph. You just can't read the entire repetition and say these are the paragraphs. My specific query is that where have you stated that the benefit of loan waiver has been already remitted or given to the concerned farmers? You just refer to the paragraph.
Paragraph 12.
Paragraph. So that should be one paragraph.
No, there are more, Your Lordship.
You just tell us the paragraph number. I am asking you time and again.
Paragraph 12.
12 and
29.
29.
And may I just read paragraph 29, Your Lordship?
I will read it one by one.
And paragraph 30, Your Lordship, we have stated why the NABARD, in a most illegal manner, has directed that all this should be refunded.
Which is that which paragraph 30?
Paragraph 30. Paragraph 29, we have stated that the consequences of the re-verification report prepared unauthentically in the manner aforesaid is disastrous, as the names of genuine eligible claimants have been struck off, omitted, causing great miscarriage of justice and causing acute complications, as the PACs have already issued loan waiver certificates to the beneficiaries. Paragraph 30, that on the basis of the absolutely unjustified, faulty and unacceptable re-verification report got prepared in the manner aforesaid, the Managing Director of the Dhanbad Central Cooperative Bank issued letter number such and such dated 16/12/2013 and letter number such and such dated 20/12/2013 to the concerning PACs, directing them to ensure refunding back of the ineligible amount identified in the illegal re-verification report, and simultaneously directed
This paragraph number, the documents in paragraph 30, which is actually pinching your shoes, are not under challenge specifically in the writ petition. That is not under challenge.
It is under challenge.
No, this letter dated 16/12/13
Yes, Your
and
Lordship.
20/12/13.
Yes.
Which is that prayer?
Yes, Your Lordship.
Which is that prayer where you have challenged these two letters?
This is, Your Lordship, paragraph.
No, your prayer.
That re-verification report is not under.
No, but Your Lordship, please just have a look to page number 3.
No, you
Page-
just
To
raise
for
number.
quashing the impugned letter number such and such,
Which such and such is which date?
dated 12/2/2014,
Yes.
annexure 13.
Yes.
Whereby and whereunder the Deputy General Manager NABARD has directed the Managing Director of the Dhanbad Central Cooperative Bank to refund the amount of rupees.
That is a separate thing. There is a specific direction to the PACs to explain as to why legal action should not be initiated against them for submitting wrong claims.
Yes, sir.
There is a specific letter to that effect dated 16/12/13 and 20/12/13. But that is not under challenge.
On the basis of that, Your Lordship, that order has been passed by the NABARD.
That's so specifically this direction that as to why legal action should not be taken, that is not under challenge, and pursuant to this, some PACs had represented before the managing director.
That is our letter. The letter of the PACS.
So genuineness of the claim. Since your case is that your claim is absolutely genuine, we take it that your claim is absolutely genuine. That whatever claim you have filed, so if they want to verify the genuineness of that, you should not be having any objection to that.
No. We are saying that please verify in our presence. In our presence, not behind our back.
Okay. So you will be in a position to produce all the beneficiaries
Yes. All the beneficiaries, Your
who
Lordship.
have already been granted and whom you want to be granted.
Yes. For
Because
example,
first the verification of the persons whom you have already
now
granted.
Your Lordship will please see. X, farmer X, he is entitled for a relief of rupees 10, waiver. For that, Your Lordship, when 10 was counted, the total amount came to 30 crores. Out of that 30 crores, 17 crores have been paid. So, Your Lordship, already the waiver has been given to him of 10 rupees. But for that, Your Lordship, the bank has already got 5 rupees. So, this 5 rupees, we are wanting that it should come from NABARD. Because 10 rupees loan waiver has already been given to X as per the scheme of 2008. And they have retained that.
And if one or the other claim is incorrect, then waiver is also incorrect.
Yes.
If any claim, suppose it is more than 50,000 rupees. If the claimed amount, because some of the report says that for amount which was not even they were entitled, the waiver was claimed.
Yes.
So that has to be rejected?
Yes, that has to be rejected. And Your Lordship, for that, this amount of 1 crore 47 lakhs was to be refunded out of the 17 crores. Ineligible amount. This is called the ineligible amount.
That's
That is all. Yes. The only two things I have heard with respect to the maintainability, they have challenged the letter dated 14 to 2012 to 2014, which is addressed to the bank, not to the PAC. So he has no locus to check.
Further?
And further, the audit report of the registrar itself says that there are various lacuna with respect to disbursement. So entire amount has not been disbursed. Para 19 I am referring.
That's true.
यूरोपीय भेजना था, लेकिन कुछ पैक्सों के द्वारा यह ऋण मानक तिथि के विपरीत दावा प्रस्तुत किया गया। कुछ पैक्सों का दावा सूची पर पदाधिकारी की टिप्पणी पर लिखने का पैक्सों को सूची पर प्रतिकूल टिप्पणी को काटकर अनुकूल टिप्पणी की गई है। These are the findings. And third, last submission is your lordship that so far as the re-verification is concerned, they have said that it is a wrong re-verification, but I have specifically stated in my para 7 that as per the re-verification side, the bank reported an ineligible amount of rupees 24 crores in respect of PAX. तो पैक्स ने 24 करोड़ का irregularity किया है. So that has not been answered in his rejoinder affidavit. So large number is a vague thing. Your Worship, large number of people has been given the benefit. Each and every person has to be
We
given
need to raise, there is a reference. Arguments concluded. Arguments concluded. I will put a date for the judgment. किसी को भेजिएगा dictation के लिए.
48 and 49, I have mentioned that 115 Your Lordship has any time may be fixed on Monday or Tuesday.
It will be taken up on Monday. Monday को.
I will
Tuesday को supplementary list.
Yes, Tuesday.
Friday को case